This case shocked the courtroom. Man with multiple drunk driving offenses stood before the judge once again. What happened next shows how serious repeat offenses can become. The next case is the State of Michigan versus Aaron Paul Peterson. This is case number 25-14103F. The court asks both sides to announce their appearance.
All right, thank you. Meanwhile, the court will just go ahead and note Mr. Jeff Harrison is here.
Indeed.
And also standing next to him is his client, who's not in pretrial custody. You may be seated. Also here this morning is Mr. Sean Van Atmel. He is the agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. We are here for sentencing in this case. It involves a single count conviction by a plea for operating while intoxicated as a third or subsequent offender. Mr. Nate Carnes, the Chief Assistant Prosecuting Attorney, has joined us here in the courtroom. And both of you stood up, so that makes me think both of you got something to say, which is okay.
I just have trepidation with regard to proceeding this morning, Your Honor.
Okay.
As the court is likely aware, there's a Killebrew 4 sentencing pursuant to the Sobriety Court program, but I do not see any of the Sobriety Court paperwork. I did not get a verification that it was submitted to the court. I have no idea that it has been.
I have nothing here.
At that juncture, I guess, Your Honor, I would request a brief adjournment so I can find Mrs. Narrowit to determine what the holdup is.
Yeah.
The referral is complete. He's been accepted into the program. He's completed all of his requirements on his end, and she has indicated to me that he is, quote, accepted into the program.
All right.
But there was no follow through with the court, and I apologize for that.
All right. Let's take a anything else, Mr.
No, I'm sorry, Your Honor.
Mr. Carnes.
Your Honor, I think it's appropriate to adjourn, given that I do recall receiving an email from Ms. Maravich about a month ago, and I thought that settled it, but speaking with Mr. Van Ackmel, it sounds like he never got a definite response.
Okay, well, just look here.
The court reviewed the pre-sentence investigation report. There was an agreement to place the defendant in sobriety court. But if the court rejected it, the defendant could withdraw his plea. This is the defendant's 5th drunk driving offense, has 2 felony convictions and 21 misdemeanor convictions, and in this case, his blood alcohol level was extremely high, 0.257.
And also in his blood test, he had marijuana in his system. And in this instance, in this event, it was a Good Samaritan who called and reported the defendant's conduct, tracked him down, and see here. Vehicle went into the ditch in a rural area. It was on a summer afternoon, and he refused to comply with law enforcement. The answer is you can wait, but I will not place him in the sobriety court program. There's no way I would do it. 257 with marijuana in the system, going into a ditch, driving further down the road, resisting police, refusing to get out of the car. Yeah, there's no way I'm going to give him sobriety court. So I do have to go through the sentencing, and so therefore I have to actually announce a sentence to allow him to withdraw it. So let's go over. Mr. Carnes, do you have any corrections to make to the PSI? I need to establish a sentence so that way you won't have an idea, and Mr. Peterson has a knowledge of what his alternatives are. All right, thank you. Mr. Carnes, any corrections or amendments to the report? If you need a minute, because it's probably not what you anticipated.
No, Your Honor, just need to, I thought it was this one where I caught a minor typo, but I am pretty sure it must be different. Yes, I have no corrections or additions, Your Honor. Thank you.
How about you, Mr. Harrison?
I have nothing, I have no proposed changes to the language of the report.
Okay, all right. Thank you. One moment here. I just wanted to look at something.
The court proceeds with sentencing. The defense attorney says this was clearly not Mr. Peterson's best day. He admits that Mr. Peterson has a serious alcohol problem.
Mr. Peterson has a problem with alcohol to the degree that he wanted to participate in the sobriety court program. I understand. I'm not going to argue about
I know.
your decision.
He still wants to participate.
I think that's compelling because one of the things that we do with sobriety court is we give the potential enrollee a clear understanding of the obligations that will be imposed on him during the pendency of that program. He was willing to do all of that because it's time. It's time that he do something about this situation, about something that started out as a social habit, as we've often seen, into a problem because of the group of friends he's hanging with. Well, a couple of his friends, one of whom is present in the courtroom today, have also been through the sobriety court program. So just as social norms or social group or social whatever interactions can support someone who has a drinking problem to keep drinking, they can also work the other way. And Mr. Peterson is very confident that in his case, they will work the other way. To say that we're disappointed that with the court's decision with regard to sobriety court is of course understandable, I think, by everybody involved, because Mr. Peterson actually looked at this as an opportunity to make that step that he's known for a few years he's had to make. You described the events in question that evening. They're ridiculous by any stretch of the imagination.
The judge explains that even property damage accidents must be reported. Leaving the scene is illegal, Mar. Peterson continued driving while drunk and went into downtown Cadillac. Police later contacted him at an Arby's drive-thru. The judge says this is not a small issue.
It is a big deal. It's a big deal because it was another reminder to him that he's got to do something about his problem because he could end up dead, which is the most likely result, unfortunately, of continuing to drink and drive, or in the abstract, a significant time in prison. Well, we know, dealing with the courts, the way the statute's set up, the way the sentence guidelines work, that a lengthy prison term is not likely at this juncture in his life, but it's a wake-up call because of the guideline that he scored. He could go to prison for this. That was something that I think you can tell people in the abstract, hey, you know, this is a felony, and socially it's, you got a DUI. I don't think the full impact of the potential consequences of their behavior is foremost in the front of somebody's mind until they get into a situation like this and they see that guideline on the paper. And that is what causes them to react in such a way as to, people call it a come to Jesus moment. And that's certainly the case here. I would encourage the court. I know the recommendation is for 180 days in jail and a lengthy period of probation afterwards. Of course, probation is appropriate. Of course, he would be on probation if he were in the sobriety court program. Of course. At this point, he barely gets by on his employment as it is. Putting him in jail for 180 days would likely cause him severe financial hardship, not the least of which he's in a precarious situation regarding the property taxes on his home. And notwithstanding, I know those aren't criteria that courts need to consider necessarily in arriving at a sentence. I want the court to balance this against the fact that he was considered to be a viable candidate for the sobriety court program. That, I think, speaks volumes to his commitment to sobriety, if nothing else does. Thank you.
The prosecutor says he was shocked by the defendant's record. There were multiple past driving offenses, including driving without a license. The court says more accurate information should have been reviewed earlier.
Something I will look into. That being said, and I do agree this is a more egregious than normal OW Black 3rd, for all the reasons we stated. But the defendant has done well on bond and clearly needs help with sobriety, so I'm still asking the court to follow the Kilbrew agreement in spite of all the extremely valid reasons the court has to not follow it. Thank you.
Thank you. Mr. Peterson, you have the right to make a statement if you choose. Sir Harrison can tell you whether he can give you advice about that, but now is your time if you choose to make a statement. Is there anything you wish to say?
No, sir.
All right, thank you. This is no way I'm going to put you on sobriety court. I know they might approve you. I don't know if I've ever seen them not approve somebody, and I'm not picking on them. And there's a reason why this court is not involved in sobriety court. It's because I consider myself, which I am, separate from it. That way my decisions are based upon myself and my interpretation of the situation, not based upon my personal needs or desires, but based upon this court's independent discretion. For the last 23 years, you have continued to use alcohol and marijuana repetitively, and nothing that has happened with your criminal history has slowed that down. You started off in 1996 with alcohol issues as a juvenile. A month later, you picked up another alcohol case as a juvenile. 2 months later, while you were on probation, you picked up an adult charge in 1997, driving license suspended. Every time I see a driving license suspended, that tells me that the person is not supervisable, or to a certain degree, because they will disobey the rules whenever they can justify their own needs, whether it's going to work or going to a store or whatever. They always think they've got a right to drive or they can get away with it. Now, there was another charge came about a month later, but that was dismissed.
This case is a powerful reminder. Repeated mistakes and ignored warnings eventually lead to serious consequences. Justice isn't just about punishment, it's about protecting lives.